Hey, everybody. Greg Suskin, no Chuck Cook this week. Jesse Bless, Aaron Hall, welcome. This is the October 18th live stream for IMMPact Litigation, our weekly update. And we have a lot of things to talk about this week. Some new cases onboarding, some news on some other cases. So I am driving. Chuck normally is the one that, so I'm trying to figure out where he has his banners and everything like that. You will excuse me for that, but I don't even see the one on. Let's start with visa wastage, the Madhavan case, because there is news on that case, even as late as this morning, and we are onboarding a new case that's related to that. So. Aaron, do you want to give the update on that case, including our latest numbers?
Sure. We had, first, the latest news with the court filings is that we dismissed the case. We did voluntary dismissal without prejudice. And the reason for that is, as we'll get to, is that there is a new case that we are onboarding right now. The deadline for joining that is October 10th, and people who were in Madhavan who have not had their cases approved are going to be able to join without a fee. As far as the numbers, let me just look these up so I get them right. It looks like we have 176 completed, down to 100 remaining. And I think just a few of those have current dates for October. Is that right, Greg?
I believe we have 3 left with current dates. So
okay.
And those cases have actually all had some movement recently, including requests for evidence. So there's some positive news there.
We're hoping those folks will be done and complete very shortly. And then for the rest of the people, because they're not current under the October bulletin, we're going to need separate relief, and that's where this new case comes in.
Yeah, so that case is basically for a couple of different groups. And Jesse, maybe you can talk about a little bit about the legal theory, why we're suing a different agency, what we're suing over in that case, who's eligible to be in that case.
Yeah, sure. I think we have to start from the point that it's a problem, right? Because we've had retrogression now. It's made a lot of people not current. The latest bulletin, they actually added a new paragraph saying that they may actually maybe pause rest of world as well. So there's visa issues, and what we're trying to, what we've been researching and what we came up with was, and what we have proof of is that there's a statute in the INA 203E1 where they talk about how visas have to be issued, and the State Department is really responsible for that, and they are supposed to do them by priority date. And there's actually case law, meaning a court has looked at it and agreed that that's actually how the law works. And we know that didn't happen last year because there were people who have priority dates 2011, 2012, even 2013 that were skipped. And it was a combined error between the State Department and USCIS, who is responsible for the adjustment of status applications in the United States. And so that was a big problem. And there's also a related statute. So who are we looking for? We're looking to help people who were skipped. I mean, who have priority dates, who weren't considered in the right order. And at the same time, one of the other errors that both agencies made last year was the splitting up of derivatives and principals, meaning, maybe dad got his visa and maybe mom did not. And now mom is no longer current, or the son. And that's a big problem because the statute, I think it's, I don't want to play this game again, but let me try it. I think it's 203D. I could be wrong on that, but there's certainly a statute in there where they talk about how family members should be considered together. And again, in the District of Columbia, that statute's been looked at and actually said that the statute's plain, meaning it says what it says and it has to be followed. Now, all good, right? We have two legal errors. The real hurdle in our case is going to be how do we make the hurt people, how do we make those harmed, those in the audience today, how do we make them whole? And it's a mountain to climb for us, because courts generally are unwilling to issue relief for people that are not current, or maybe that have been harmed in a prior year's allocation of visas. Well, what we're saying is all well and good, and we understand that, but this unique error is something where equitable relief should provide a remedy for people, because now they may face years upon years of delays. And it's not without considerable risk, but it's, in some ways, it's either the least bad option or the one available option, other than throwing a stone up to Capitol Hill and hoping that they become awake of the tremendous backlogs and agency misfeasance. But this is our theory, this is our case, and I think. Go ahead.
Yeah, there's one other group also that could be in this case, and we may have some of the Madivan. Those three that are remaining in Madivan are the example of that, if they are not approved before we file, which are people that have current priority dates that have been waiting a long time and were skipped over the last go round, even though they have current priority dates and are still eligible to adjust now. The same thing could happen again in this fiscal year, where they were skipped, even though they have current priority dates. So just you can have a current priority date and participate in this suit as well, and that's something that if you're in that situation, you should take a look. So basically, on all these cases, we invite people to take a look at IMMPact Litigation, our website, where we have FAQs that explain the legal theory of the case and who's eligible and how that works. And I'm putting up the address there, and you can see that if you go there, you'll see the visa wastage case onboarding, and go look at the FAQ there, and you can find everything you need to know about participating in the case.
I'll just say one thing for the people who are current. If you are still current, there is absolutely no doubt that you have been skipped, right? Because we know if you're still current, you've been able to survive, and you don't have that mountain of relief that I talked about earlier. So you are an absolute prime candidate, and should really consider it, because who knows what will happen going forward. If they freeze everything, I don't agree with that, number one. But number two, you want to make sure that you have your toe in the water to get relief from a court. And that's what federal litigation will help you with. Now, Aaron raised an incredible, he's got laser focus on everything. He said that onboarding did we extend that past the 10th?
If we passed it, we're still taking plaintiffs. I'll change the FAQ on that to push it out a little bit longer. We would like to get some more plaintiffs in the case. We know, actually, for a lot of people, they have litigation fatigue, at least hearing about it. But just as a note, if you were in Madivan, if you're one of those 100 people and you want to continue litigating, you do not have to pay to be in this, and the same for the Chakrabarty plaintiffs. We know there were some Chakrabarty, we'd heard at least one Chakrabarty plaintiff who didn't get into Madivan and asked to be in this one. So if you were in either one of those cases, you can participate in this. Okay, let's talk about Go and Gomez and DV, the DV cases, and where we are on that. We have basically, I'll just start with on Go and Gomez, the cases that we're in a holding pattern on that. So if you're asking sort of like what's going on with that case, it's been argued, and it was appealed to, there was a success at the district court level, and there was a reservation of visas for the 2 lottery years. It was appealed up to the DC Circuit Court of Appeals. It was argued last month by by a number of lawyers, including a very fine job by Jesse and by Chuck and several other lawyers that were involved with the other cases. And it's in a holding. Basically, we're waiting a decision, but just know that these decisions from the appeals court are usually several months that it takes. There has to be, there's 3 judges. It will be it has to be at least 2 judges that come out on there, and there will be a written decision that will probably be fairly lengthy, and we're probably not going to see anything before January. I'd have to guess, maybe later. So if you're asking for predictions, or if you're asking for sort of like what's happening with that case, the answer is wait till January, unfortunately. But that's that being said, it's we're getting closer and closer to that, and that will be. My guess is that that's probably the end of the story. If we win, will the government try and go out to the U.S. Supreme Court? Very possibly. Will the Supreme Court take the case? Well, they probably won't, because they only take really maybe it's usually divided circuits, and we're not going to have that issue here, but it's usually only 1 or 2 or 3 immigration cases a year that they're going to take at the Supreme Court. And I don't think this is going to be one of those, but and if we lose, we will see what it looks like, but we could, we're basically facing the same odds if we lose and we try and appeal as well. So this is probably it for where this case is going. And I don't know if Jesse or Aaron feel differently about that, but that's my sense of things.
Yeah, I mean, I think that's like the kiss of death when you say this is it. And I know from our lives, as soon as you start putting a final chapter on things, you're just getting started. But
I do think we're going to get a good result, but I just want people to know that basically this is it.
We hope. Yeah, we hope.
Yeah. So, and we on DV-22, that case is over because the government did half of what we asked for, which is one half was to use up all the TV numbers, and the other half was for our plaintiffs to get their cases processed. We got all the numbers used up, so that was a victory for broader immigration law, but we still had a handful of plaintiffs that didn't get adjudicated, which was not good, obviously, for those folks, and we're sorry that we weren't able to get that accomplished. But that is the nature of litigation, where a lot of times it's not a clean win or loss; it's sort of a partial win or loss. And in that case, I think we hopefully have put the DV program on a good track going forward, and hopefully they will. The problems. I see Britt Simon's posting, but I do think that hopefully we're not going to see what we saw in DV 2020 and 2021 again, and that everybody that gets selected will have a legitimate chance of processing if they do everything in a timely manner. Okay, let us move on to Shumilina. Which is our Ukraine case, because there is some good things happening there. We were just talking before the call. It's like, how much can we say? But Jesse, why don't you give an update on what's happening on Shumilina?
Sure. Yeah. So Shumilina is based on a statute where one of the few that were passed this year that provided benefits to Ukrainian refugees allowed to enter the United States. And gave them benefits to the same extent as refugees, except for permanent residency, which they carved out. And there was a couple other carve-outs as well. But USCIS actually didn't follow that law and provide people work, which is an incredible benefit, incident to status, meaning work right away. And then
right after you get off the plane.
Right after you get the plane. And then they also required people who seeking, sometimes an employment authorization document is the only identification someone will have in the United States, and refugees don't have to they can get one, but they don't have to pay for one. And they were charging Ukrainian refugees $410, not only them but their derivatives, right? The money for that. And we sued, and we also at the same time were asking the government to fix its errors, and they didn't say no, but didn't say much. And we had to file a motion for preliminary injunction and then a motion for class certification because we wanted to make sure that everyone who was being harmed was made whole. And then the government started to tiptoe to settlement negotiations, and now have agreed with the majority of what we've asked for. And we are fairly close to resolving the case in a way that will provide the benefits to these Ukrainian refugees as the law.
How do we know that we're close to the end?
Well, yeah, well, I mean, again, it's the same problem. I just, I guess, poked fun at you about, right? I guess I say, as soon as I say the end, maybe it's just the beginning, but.
Well, we have, I mean, the government's.
We're knee deep in settlement. We're not agreeing to negotiate. We're actually negotiating on the substantive, and
there's stuff happening.
And I'd love to be able to finalize this week, but I will say, again, I'm not here to go rah for Greg or whatever, but I will on this because Greg is really the one he may have been the one person who read the law and identified the error here, and he deserves a ton of credit.
It was accidental too. I was just reading and sifting through to say maybe there's something good on immigration in this Ukrainian bill.
Yeah. But
I didn't know anything about it before I was.
Yeah, you're like the immigration reading rainbow. I mean, it was a good thing, and where everyone's going to benefit from it. It's just unfortunate. Again, it goes to show you though that everything can be clear as day, but litigation, is a tool. I always call it a tool that you can use to really get because people don't always do the right thing, and federal agencies are good about that.
Jesse, I mean, you and I looked at this and it's like, yeah, it reads that way. And I can't tell you how many people I talked to about this who were skeptical. Well, surely we would have known about this. How did this get slipped into this bill and we didn't know about it?
Some really powerful people, powerful. I always talk about these, attorneys that I absolutely respect. And I go to them all the time and say, I have to be wrong. This looks way too easy for me. And they were like, no, you can't be right. That's too plain. And we just went with it. And you know what? We are right. And it's really going to be probably one of it's probably the highlight of my year because of just the reach and the scope of trying to, it's a social issue. It's a world crisis for these folks who've been left, they didn't ask to come here and they had to come here. So they should at least be allowed the benefit of working and putting food on the table. And that's the case I love, so totally group effort and just really proud of what we hope to accomplish here.
Good. All right. So we will have hopefully some news in the next couple of days on the Ukrainian AD case, the Shumalina case, and I am very excited about that as well. All right. Which other cases do we have? Do we have news on any of our? We have some other cases that, like the EB case, the EB5 cases, and all that. I don't think there's any. Is there any news on any of those cases as far as filings or anything like that's coming up?
I don't think so. I think we have a couple other onboarding cases that we should probably touch on.
Yeah, let's do that. We have one that is. I don't think we have a banner. Oh, yes, we do. Here we go. EAD delay. So this is round 2 of our EAD litigation. And this was, some of you may remember us talking about the Kang case. And that was a mass mandamus for people that had, in that case, it was people with adjustment applications that had employment authorization documents pending. And we filed that case December or January, or that's when we were doing onboarding. I think it was around that time.
November 2021 we filed.
We filed November. And the good news in that case, great news in that case, was that the government really very quickly and adjudicated 100% of our folks fairly quickly after we filed the case, certainly a lot faster than the processing times that were being reported. That was the good news. We had filed that as a class action because we wanted to see if the government could actually fix the problem for everybody. The government used the fact that they had adjudicated all the cases as a basis for dismissing the case, saying it was moot because there weren't any plaintiffs left. And they were successful with that, and the case was dismissed. All our plaintiffs were successful, and our plaintiffs were happy. I think the broader immigration community was less so, because we didn't get the class certification and get that broader decision. But we had told the government at the time, if you win on this, we're coming back and we're going to do this again. So last night or yesterday, we told you guys, I think previously, that we were going to be onboarding soon. We had some distractions that delayed a little bit our being able to onboard, but we are onboarding now. So if you go if you go to IMMPactLitigation.com, you will see and click on onboarding cases, you will see that case. And this go around, we are going somewhat broader as far as the EAD categories that we will include in the case. There's a couple of exceptions. One is the asylum-based EADs. They have different litigation that they're involved with, so they don't need to be in this case. But that being said, it's a fairly broad group. So if you have an employment authorization document that you have been waiting on for a while and are getting tired and need it, then this litigation might be for you on there. It's paired up with a second case. I don't know if we have anything to say more about that. We just started onboarding. We'll be, I think, onboarding for most of the rest of the month. And then we will hopefully file in early November on that case. So it's not very far off on that. Anything else to add, guys?
No.
Nope.
All right. The other one, I don't know if Chuck has a banner for it. I don't think he does. I have to figure out how to make one, but I'm going to take this off because we promised we were going to sue on advanced parole applications, and we have started onboarding for that case. So if you have an adjustment of status application and you've filed for an advanced parole document, I'm very sorry about that you are likely facing, I don't know what the weights are, but it seems like typically a year or more now on getting an advanced parole application. It's almost a waste to even get. Because in some cases the adjustment application is already done before the advanced parole application is even being decided, and that's not so fast. We need to fix that, and one of the ways that you can fix this, other than complaining about it like we have through our liaison channels with our organizations, is to sue. And this is our first go at advanced parole filings, and that case is now onboarding as well. There are some people who will be wanting to sue on both employment authorization documents and advanced parole applications. We have kept the fees lower than in our other cases, assuming that some people are going to want to sue in both cases. So if you're in that situation, take a look at the FAQs for both, and you are welcome to be participating in both lawsuits instead of just the one. So that's advanced parole. That is onboarding now. We also, just to give you a heads up, we just signed off on the FAQ internally, and we are building onboarding apps that will probably take no more than a couple of days. So by the time we are talking to you next week, we will be onboarding this case. I know a lot of us are excited about it. Every lawyer I mentioned this to is super excited to hear we're about to litigate on this issue. But I-601A provisional waivers. This is a waiver of the of reentry bars. It is something that used to take only about 4 or 5 months for USCIS to adjudicate. Now we are looking at. We were just talking about this yesterday. Nebraska Nebraska Service Center, Potomac Service Centers adjudicate them, and they're both ridiculously long. It's like like 27 months in one and 34 months in the other.
Yeah, it's maybe with a half in there, and it's only, and again, when they do this new thing now where it's only 80% that's actually at that, right? So it's 20% that are actually waiting longer. I think that, so for everyone who doesn't understand what a provisional waiver allows you to do is It's essentially, it allows you to stay in the United States before your consular process, meaning you go for an immigrant interview abroad.
Mm-hmm.
And only certain people qualify for it. However, they don't allow the individual seeking that waiver to wait in the United States and work, right? We talked a lot about work today, but and so it's a double-edged sword. And so by keeping them locked in this provisional waiver period, you're harming the family unit, which is what you need to have in order to qualify for this waiver, because the people can't work. They're trapped here. And I know I've spoken with a number of attorneys, and we have an election coming up in November, but then we have an election coming up in 2 years as well for the presidency. And I know a lot of people are like, if I need my I need my provisional waiver before that election. And right now, those processing times would mean I probably wouldn't get it. And
yeah, I mean, it's not just harming the family in the United States because of the inability to work. There are a lot of people who have close relatives outside the United States, and they are essentially forced to stay in the United States, or they might face a 10-year bar on coming back into the country. And they have family that they haven't seen in years and years. And some cases, you have somebody that's on their deathbed abroad, and the family member in the United States is helpless to do anything about it, because these waivers are basically they're essentially not being worked. I think
there's this additional phenomenon going on right now that's really frustrating for people, I think, and it's that in removal proceedings, when people are in immigration court, oftentimes they're eligible to apply for some kind of relief from removal. And one of the most common kinds is for people with family here in the United States is called cancellation of removal. And so the immigration courts are kind of overwhelmed with these cancellation of removal applicants. And what the Department of Homeland Security has been doing over the course of the last year or so is encouraging these people and often moving over their objections to dismiss their cancellation cases, saying, you know what, you can do the 601A. You're fine. You have this other thing you can do.
That's crazy.
And then they lose the work permit that came with the cancellation, and they get into this other process, this I-601A, which is all well and good, except for the fact that they're processing it 37 months. And so they've basically taken away the person's ability to provide for themselves and their family. So I think the problem is getting worse, not better, with what's happening with the immigration court system.
Yeah. So we are we will have that FAQ up shortly. We've been having sort of an internal debate about how long the case should be pending. I heard an interesting. I had a discussion yesterday with a lawyer that we all respect, who was telling us that should be more, you should be aggressive and go earlier, because the fact that they are saying it's 34 months in their processing time shows that they're not, it's bad faith in and of itself there, and that that if you even if you recently filed the case, that they're not going to work on your case forever unless you litigate on there. And it was like, yeah. I guess there was that was an argument that was made in IA 29 EB5 mandamus litigation, where somebody successfully made that argument that didn't have a case that was pending all that long, but was still successful because the processing times were something like several years out, when they were 5 or 6 years out that they were working on IA 29s, I think. So anyway, I think we've settled on a number for it, but we'll have more to say about that next week when we're onboarding for that case. So keep an eye out for that.
Is there? I'll do this right here in the live stream. I'll ask you guys for an opinion. Is there something the agency could do, some kind of interim benefit that they could provide, to allow themselves to dig themselves out of this hole while not harming people? For example, why couldn't they say that anybody who's kind of prima facie eligible for one of these waivers gets deferred action, and then allow them to get a work permit, so that recognizing it's going to take a long time to dig themselves out of the hole that they made, they can do that while not harming people?
Well, I've always said, if you want to find a good agency process, look to the U visa. No, right? No, because that's what they did there, right? They wanted to do this bona fide determination and wait list. I think the way to dig it out is to own the issue, right? As little as 2 years ago, they were under 15 months, right? Okay, and now there's you can't tell me there's a rationale that would say now we had to double that time. I think honestly the interim benefit should be work authorization as far as I'm concerned, and maybe even advanced parole for.
But I think deferred action is. Yeah, I mean, you can't just say that you're going to give them work authorization. You have to do it through some mechanism. And I think deferred action makes sense. One of the reasons why I like that suggestion, Aaron, is because it has to be case by case in order to make, probably thwart litigation in the other direction. And one of the things that all these cases have in common is people are providing a lot of evidence about their circumstances, and that they are, that they have they have sympathetic circumstances, and they've already. So it seems to me that deferred action would make it be fairly easy to adjudicate just on the basis of the evidence that's already provided in the 601A case. So,
and to Jesse's point, I just pulled up the historical processing times on the USCIS website, and it's just remarkable that fiscal year 2018, that's not that long ago. Their median processing time for this kind of application was 4.5 months.
Yeah. Yep.
So, yeah, I mean, that
was Trump, and that was during Trump time.
Mm-hmm.
Yeah, they were probably all denied, but still, I mean, I'm actually of the mind with all these administrative. We always try through, and I'm not like, these kind of layer on, stopgap measures to bail out the aid. It's just not working. We need to just own the issue. Like you said, you don't need additional staff. You just really need to get better at your work and work product. And that's the, I think the COVID excuse, I know it exists. I know people who have it, but people are working again, and it's time for the agency to come back online and then adopt technological advances. Greg, I know you're the master of that. Well, teach them, for God's sakes.
And I'll say the USCIS policy manual, which gives their adjudicators guidance, it's very specific about the one thing that they're really looking at with these applications, which is extreme hardship. And it lists these factors that should be particularly significant in leaning towards a grant, and they're easy to identify. So, I mean, they just need to be quicker. That factor's there. All right, that looks like an approval. Let's go,
Yeah, I mean, we'll see if I haven't heard anything in a while, but, the USCIS is promising that they were going to be back to almost full strength by I think we lost Aaron, full strength by the end of the calendar year as far as their staffing goes. So, we're not seeing evidence yet in several of these categories that these people are on, that they are actually making any progress. Aaron, I was just saying before you got knocked off that, we're supposed to be at close to 100% back to pre-pandemic employment at USCIS. Plus, I think they were expanding with all this extra money that they've been getting. So that's we're not seeing that yet evident in the data as far as processing times goes, particularly in some of these new cases we're litigating on.
This is my last commentary of the day, but I will think like the delays are a net loss for everyone, because by the time they adjudicate hardship or eligibility, circumstances have changed, and which necessitates either new evidence or requests for evidence. It's just a downward spiral, and it's like nobody would operate this way, right? It only we, and I am I'm an owner of this process, right? Only we would adopt this type of adjudication, right? It doesn't work for anyone, not the agency and not the certainly not the beneficiaries.
All right, let's get to some questions. So we will start with Trey. Nice to see you again, Trey. Trey's question is we have had, during the height of COVID, there were people who actually did get DV in process, but they got stuck outside the United States because of lockdowns. And I don't know, I'm trying to recall how they were dealt with in the litigation, in any of the cases on there, those people who were granted, but because of lockdowns weren't able to get in. I don't know that they are in the scope of the cases or not, but I'm just curious as far as what you would, on Trey, if there's anything at this point, if somebody was, for example, subject to a travel ban or something like that, and they weren't able to enter, even if they had the visa, what is the litigation? Is Gomez or Go helpful for that population at this point or not? I mean, I don't know if they would be potentially covered in the settlement, not the settlement, but the judge's order.
So it depends. So for us, there were people who were not processed and adjudicated. So if you got the visa, there was actually a mechanism by which in February of 20, the Judge Mehta automatically extended it. So I would need more details here because a lot of people who are actually able to have visas that lapsed, they were automatically extended by the judge's February order. So they were given 6 months additional. So I would need more there. So I don't, if you timed out, meaning you didn't travel on the visa that you received, I don't think that would be that would meet the definition of our class. Absolutely not.
All right. So is there any, what do you think that there's any potential legal theory for somebody in that situation, or are they kind of in a tough spot?
Not through our litigation that I see. I just don't. Our definition were for people who actually did not receive visas, and those that did, who were class beneficiaries, were provided an extra benefit so that they could travel on those visas.
Okay. All right. So, Frostman, we talked about Go before. If you want to go back and watch this, but basically, we're just in a holding pattern, waiting on the case from the DC Circuit. So probably not anything for 2 to 4 months, probably somewhere in that range. Unfortunately, it could be a while. Okay. Go case possibility judge. So on that, I guess that this is sort of like we didn't really talk about sort of like what the range of possible outcomes are in that litigation. So Jesse, I guess that let's just say that the issue is, that we're successful in at least making the argument that the district court decision to reserve visas was correct on there. What about the number that the judge came up with in those cases? We argued that we did make the argument that the number was unduly conservative on there, but so I guess the answer on that is there is a possibility that number could increase. So it's sort of like you have to, first hurdle is, do we win at all on the reservation of visas and upholding the lower court's decision? And then if that's the case, then, and they want to take a step further. So I think that's like a more remote possibility than just getting Judge Mehta's order upheld. But I don't know if you guys have a different view of it. I would say that it's probably going to be, that's a tougher hill to climb than just the first one. We will see.
That was always going to be a tougher hill, but we made the argument, and we do think that Judge Mehta was overly conservative in the numbers, but frankly, at oral argument, it was a little bit hard to tell. It was a number of hours of oral argument about these issues, and it was hard to tell how engaged the panel was on that issue during Chuck's portion of the argument. So I didn't really get a sense of to what extent they're really considering increasing the number for Go plaintiffs. Go ahead, Jesse.
I was just gonna say, I thought Chuck did a really good job showing that it made really no sense to only provide a benefit to half of the plaintiffs or whatever the number was, and that they all shared in the harm and all deserve to share in the remedy. And that's just for 2021. I think that there was little to zero chance of 2020 Gomez class being raised above 9,095. I don't see that, but I think for Go, Chuck made the best case possible. And I thought the judges were engaged when I was there in person. I thought they were. I mean, Judge Katsas and Srinivasan were engaged. Henderson had made her dissent is already hopefully written. Will be coming out later.
Never know.
No, I know. No, I will do my own private, like, come on here in like some type of costume if she goes to the majority.
All right. So Simon was noting, and I appreciate it. Actually, it's good to have him into watching this, because he's usually a lot more knowledgeable than anybody as far as what's happening with DV, and says that the DV 2023 is normal processing, and it looks like they're doing it the way they're supposed to do it. So that's not something that we are thinking about at this point, DV 2023 litigation, because it looks like the government is doing their job. And that's why we sue. We're not just looking to sue for the sake of suing. We're suing to try. That's why we're called IMMPact Litigation. We want to actually push change. And as Simon noted in his next comment, that the litigation was one of the reasons why past litigation is the reason why we don't have to sue this year, because it looks like the message was received, and they are doing give the State Department some credit. They're doing a much better job in that department than they had in the past. So that is not something that I don't think you need litigation at this point. If you were selected in the DV lottery, and you're filing everything in a timely manner, you have a real shot at this. We saw last year something a little unusual, I think, because it was partially because of and Simon may have some thoughts on this, but I think that the number that they select is always based on what they anticipate is the number that they need. I don't think the government deliberately picks a lot more people than they're going to be able than they would be able to process. I think that because the prior numbers were so screwed up because they didn't adjudicate all the cases, and because of COVID really kind of messing up their calculations, I think they were, they picked a lot more because their algorithms were messed up from the last couple of years. So hopefully this year's number was a little bit closer to what the actual number is, and there won't be people at the end who did everything process and don't get a chance to come into the U.S. because the numbers got used up.
I think I'm going to have to channel my inner Brit, because what he would say, I think, Brit, tell me if I'm wrong, he would say they always select 2 times as many, because a third are not going to show up or follow through.
Right.
A third are going to be ineligible. And then the government, to their, I guess, credit, wants to have enough people in the reasonable available pool so that they can use all the visas.
Right.
And they can't do that unless they select 110 to whatever, 120.
Right.
So,
but there's a method to how they do that, which is what you're suggesting, which is that they're not just deliberately picking a lot of people so that and then people get screwed, like on there that actually got selected. Their goal is for everybody that gets selected that wants to come to the U.S. that can properly file an application to have a legitimate shot.
I think where that program has room to improve is the discrepancy between certain posts who don't play the game, and their kind of willful blindness to Accra or Addis or Sydney for the better half of 2022. That's where the program has some gaps to fill from I
agree. That was the one. If they fell down on the job this year, was that there was that not everybody had a legitimate shot.
No, kills me. I know.
So, all right. I think this is a good question on regarding Go. So let's say that after that decision comes out in January or so on there, how long will it take to know whether the Supreme Court is going to not, how long will it take to know that that's the end on there, and that the Supreme Court is not going to be taking it? Do you guys know about how long the Supreme Court, like how long they would have to basically make a decision on whether they were going to grant cert or not?
I don't.
There's a specific time rule. I don't know if it's 60. I want to say it's 90 days, but I think it may be 60. And then you have to file the writ, which is essentially a notice, and then the court can ask for a response or not. But so the first step would be, is the government or the losing party taking it up to file a writ? And then it becomes, is it going to be, granted? Writ of certiorari. Is it going to be granted? Is there going to be response to? There's a long decision making, but it would probably be on the 24 calendar, right? Because they're in 23 already.
Yeah.
And they're taking cases for the fall of 23 right now. So this would be
It would be a long time. We'd be waiting.
This is an election away, probably, right?
All right. So I think this is an interesting question about, like, let's say we get a win in Go, and in that case, I guess the question here is, what, we can speculate a lot on what the remedy would be, but let's just say that, this is a chance for us to say what we don't know on here, which is, all these visas that have been reserved. Let's just say that the Judge Maida's order is upheld. We are with the number that was reserved in that initial order on there. What one of the things that we don't know is how the State Department would actually allocate all those numbers. Would it be in case order number? Would the regions get it proportionately to how they were drawn and how they would normally get allocated? There's like a lot of things that we don't have any idea about how that allocation would work. If it's the way the State Department seems to have done everything in the last couple of years, it'll probably be completely random and haphazard, as far as how it happens. But hopefully it won't, and that people will at least have some way to know that they got a legitimate, that there was a method and that they had a legitimate shot at the, at getting in that second lottery, which is essentially what it would be. There was a related question, but I guess the bottom line is that there's a lot. The judge is going to have to presumably, once this is being administered, they're going to have to submit some kind of plan to Judge Maida. Is that probably what would happen? And then we'll have a better idea. Sorry, Aaron. Aaron, hopefully, here he is back again. That was fast.
I don't know why I keep getting booted, but I was going to say, I think that Greg's right. We don't know exactly how they would be allocated. But I think what this question about ACRA was probably getting at a little bit was just the fact that they did such a bad job over the course of the year. Does that mean that they have a lesser chance? And while we don't know, my expectation is that the visa number would be allocated by plaintiff first, or by case number first. So it would be my guess again, is that it would be assigned to a certain plaintiff. And so if that person happened to be in ACRA, they would get processed. It wouldn't just be ACRA's not doing DV. It's coming from a court order. They're gonna get processed. So I don't think that the fact that a person is in ACRA is going to cause problems. And then to the second question, what if a Go plaintiff is in the U.S. on a tourist visa? Could they adjust status if we win? I think I've heard some of Chuck and maybe you guys speculate on this. I'm not so sure. I think they should be able to, but the USCIS, who does adjustments of status, they are not a defendant on this case. And so a court order is not going to be directed at them. Now it's directed at the Department of State, who could tell USCIS that a visa number is available, but I'm not sure. And I don't think we would know that for sure. And certainly not enough to advise somebody to try to adjust until at least, we have some details about how the order would be implemented.
And what scares me about this question is, if you're on a tourist visa right now and you fall out of status, number one, you have an intent problem. Okay. Yeah. Number two, you may fall out of status. So I would assume you're consular processing, meaning you're going abroad if you win.
Yeah, and I'm just noticing that Britt in the comments was explaining why he thinks that's a bad idea to take that strategy, and I think he's right. So finally got my LinkedIn back and streaming working correctly now that I was the one who was logging in instead of Chuck on there. I was able to fix that before the call. So we are streaming on my my LinkedIn this week for the first time in probably a couple of months. So Leah had a agreed on deferred action as a remedy in the 601A case on there, and that will be something that hopefully will be achievable on there, in addition to actually getting these cases adjudicated quickly. Joe is Russian and is in Kazakhstan and wants to know about judges deciding faster than January. So he didn't have to say it. He sounds like he's in the Go case or Gomez. And let's see, my money's going out of my wallet. Can you call him right now? The answer on that is no on there. That's that would be nice, actually, if there was premium processing for getting a verdict or a decision from a court on there. But they're going to do it at the pace that they're going to do it, and it could be faster than January. It's just unlikely on there. I mean, they do. If it was Trump and searching Mar-a-Lago, they'll come out with a decision in about 5 minutes, which just happened at the circuit court in that case. But generally speaking, we're telling you January because that's basically what they average.
Stay safe, Joe.
Yeah. Yep. All right. What are the chances of documented dreamers? I do think, actually, even though this is, I didn't do a legislative update or a regulatory update, but I do think that. So just to let people know, on the DACA case where we are right now on that is because it affects this question, even though it's not directly related, that the Fifth Circuit basically just gave temporary reprieve to the DACA program, basically kicking it back to the lower court, but still saying that it's their sort of inclination, I guess, that the whole idea of deferred action, the DACA program is illegal, even if there's a regulation that the Biden administration put out, and that's addresses some of the issues that the lower court had. Judge Hannon, I think it was yesterday or the day before, said that temporarily he will leave the program in place while he's reviewing. But the reason why I'm mentioning all that as background is that there is a renewed effort right now in Congress to try and deal with this issue. I think there might be a shot at it during the lame duck after the election in a couple of weeks. It's the kind of issue that there are a lot of Republicans who are sympathetic on the population and might do it. And that's a one period that you have after the election where, especially, people that are leaving Congress might not really care about casting a vote one way or the other. But that's there is some hope that during the months of November, December, before the new Congress is sworn in, that we might see action on that. Now, as far as documented dreamers, that is one of the issues. There were about 5. I did an article on this a couple of years ago, but at one point there were 5 different versions of a DREAM Act that all covered different populations, and there were 1 or 2 out of the 5 that had documented dreamers in there. That language, and I actually helped with some drafting of language to get that population included, that made it into one of those bills. But that's something that we will keep an eye out for and talk to you guys about if there's news that's happening on that. But that's probably what I think we're looking at there. And the other thing I would just mention is, this election is huge from an immigration perspective because the Democrats actually have a legitimate chance at kicking up a couple of Senate seats. And that means in the Senate, at least, they could actually get rid of the filibuster and pass immigration bills, which they haven't been able to do for the entire course of the Biden administration, despite the House sending over some pretty great bills. on there. And then, of course, the House has to actually keep, that stay in Democratic hands. That is, I think the longer odds right now on that happening. But, we just don't know. So if the Democrats win, they keep the House and they get 2 more Senate seats, which I would put probably 50-50, 40-60. It's not going to be an easy lift. Then a lot of good things are going to happen, I think, from an immigration perspective in the next Congress on there. That's what has to happen. It's a heavy lift. If it doesn't happen, then my guess is we're going to see 2 years of stalemate in Congress continuing on. And you might see the president being more aggressive on executive action, knowing that there's basically hopeless for him getting any immigration legislation done. All right, I think we should end here. And like I said, next week we will have. One thing that we decided in the private comments here is that we're going to update the FAQ for the visa wastage case. And we will continue. We're going to extend the period of onboarding until the end of next week. So if you're watching this on the recording, that you can still participate in that case. So we'll get that updated on the web page, and hopefully you guys that are thinking about it will go ahead and proceed with that. It's I think better than sitting on your hands, but that's where we are. Any final thoughts, guys?
No, thanks all for joining.
Yeah, thank you.
Hopefully we'll have Ukraine news next week too.
Sure.
All right.
Bye-bye.
Bye-bye, everybody.